Good morning, everyone, and welcome to the First District Court of Appeal. We have three cases on the calendar this morning, and we'll begin with the first one listed, which is Consumer Rights, LLC versus Union County. Counsel for the appellant may proceed when ready.
May it please the court. My name is Robert Earl Case, Jr. I'd like to reserve 4 minutes of my time for rebuttal. I represent the appellant, Consumer Rights, LLC, in this case, who is the plaintiff below in the trial court. The order being appealed today is a final order on plaintiff's complaint to enforce the Public Records Act, which is Chapter 119 of the Florida statutes. I represent the plaintiff, and in doing so, I made the public records request that started this whole case. And I thought what I made was a simple public records request of Union County for the work email addresses of Union County. When I didn't get a response, no acknowledgement of the public records request in the first place, and then I didn't get the records, I filed suit some 4 months after having sent the public records request. The trial court set an evidentiary hearing, which was conducted, and after that hearing, the trial court entered the order that's on appeal today that dismissed the public records complaint in its entirety. And the order has a number of rulings that I assigned error to throughout my brief. The first one, error, it was error to say that the records requested didn't exist at the time of the request. The individual work email addresses of Union County absolutely existed. The trial court even acknowledged that they existed in its order, where the trial court said that the records requested by plaintiff have been provided.
Well, there was no list. I mean, that's what the trial court found, and that's what the evidence showed. There was no list, no piece of paper they could pull out and say, here's the list of emails, right?
No, sir. That's absolutely correct. The trial court found that. I don't dispute that.
And so to have a record in existence, they would have had to go through pieces of paper somewhere and say, well, there's Jim's email, there's Bob's email on these 50 different pieces of paper. Is that what your view is?
No, sir, that's not my view. My view is that the clerk testified that they used different computers to send work emails, and that when they actually produced the list, they went to those computers and pulled those email addresses and provided them. So my view would be that these email addresses are computer records. The law says you have to give copies of computer records. The law also says you use the computer system that you use to access those computer records. You go use that computer program, go to those computers, and pull those work email addresses. I said, you may have to do it one by one. That may be tedious, and they may have called me and said, you need to pay us money for this because it's going to take us.
They couldn't have called you because you just left an email address saying, I want it here, I want electronic, I don't want paper, and that was the only choice you gave them, wasn't it?
I
did only give my email address. I'm sorry. I should have said they could have emailed me and said, hey, we got your...
Well, is that reasonable to expect them to email back to an email address that doesn't even look like a real person? The email address was ask4, with the number 4, records.com,
yes,
or
sir.
excuse me, gmail.com.
Yes, sir.
And the question I have is, the Public Records Act says that a person is entitled to get public records. Is a governmental entity required to provide records to an email address that doesn't appear to be connected with a person?
Yes, sir.
I mean, how do we know there was any person involved? A computer could have generated that email address. It could have generated the message that went with it. It could have sent it remotely to hundreds of governmental entities. I mean, there's no indication that there was any person who actually, other than the fact that the script that went with the email appears to have been written by a person. What are your thoughts on that?
My thoughts are this, Your Honor. First of all, the law is clear that a corporation is a person within the terms of the public records law. And the law is also clear, and there was a recent case on it, the Chandler versus City of Green Acres, that said that...
You didn't ask, I read that and I understand all that. You didn't ask for these to be sent to the corporation Consumer Rights LLC.
That email address is used by Consumer Rights LLC. And there's a specific purpose for making them anonymously. It's a business purpose that Consumer Rights has. I don't want to get into that unless you need
I
me.
understand that. I understand that you don't have to say who you are to get public records. That puts a chilling effect on the law.
Yes, sir.
But you have to be a real entity or a real person. And the problem with an email, particularly one like this, is it could have been one of thousands of different scams that exist around the world. People don't lightly open emails like this or respond to them. I mean, that's, if you received an email like this from somebody you didn't recognize, and it had an attachment on it, would you open the attachment?
I would not open the attachment
think you
because
would.
that's where the scam is. There was no attachment to this email address. And if I was a government agency that's supposed to know and understand that people, whether it's Consumer Rights or whether it's Joe Blow on the street, can email a public records request to them and do it anonymously, and they're not going to get their name, they may not have their name, they may not get their address, they might not get their phone number, but they still have a duty under the law, and it's clear law that they have to respond, first of all.
Well, let me ask.
Send the records.
You didn't send the request, though, to the records custodian or the designee, right? You just sent it to a random email address. Had you the record on appeal shows that you knew the clerk of the court was the records custodian. The custodian was not sent the record. It was just sent to some unknown email address that turned out to be a county employee monitoring it, but not the custodian or designee, right?
No, sir. I respectfully disagree. First off, there's different people or entities that can be custodians under the law. And the number one, I think, is that the statute says the head of the agency is the custodian. So if you don't want to do a scavenger hunt or figure out who actually has possession of the records, you send the public records request to the head of the agency, and you can rest assured.
And that's the clerk of the court here, and you didn't send it to the clerk.
Clerk of the court's not the head of the agency. The Board of County Commissioners is. And where I found that email address, and it's clear in the record, and it's unrebutted, and they haven't denied that that was the email address for the Board of County Commissioners, is from the official minutes that were done just prior to my sending the public records request. I had a notion that the clerk of courts was the internally designated custodian, but I also knew the law that said that the head of the agency is the custodian.
What would you say to somebody who says, this is just a scam? This is an effort to create a lawsuit. It's an email that you sent with the express hope that you wouldn't get a response, so you could file a lawsuit and get attorney fees. What would you say to somebody who says that?
I'm glad you asked that because I've been seeing that in the media about these types of public records requests, and I would respectfully disagree. If you read and understand the law on the public records law, all I want is for the public records law to be what the appellate opinions say it should be. Their legitimate purpose for making a public records request is to make sure that the agencies understand and comply with their obligations under the law. And enforcement is critical to that.
Well, what you're talking about now is being a public watchdog, and that's wonderful. But what you were telling us earlier is you had a legitimate business purpose for making this request. I don't care what that purpose is. I have a suspicion of what it is, but that's irrelevant to the legal analysis here. I guess what I'm struggling with here is all of this law about anonymity and those sorts of things seem to be developed in the situation where somebody walks into the clerk of court, walks into an agency and says, hi, I'd like a copy of such and such. And there, that has said, you don't have to give your name. We live in a different world now where things are coming from Nigeria and everywhere else. So shouldn't the law be different, or why shouldn't the law be different in the context of the electronic world versus the context of the walking up to the front desk world?
I don't necessarily know that that's the delineation on when you can make an anonymous request and when you can't. I understand the concerns with the electronic world, but you've got to balance that against the concerns that you don't have to tell the government who you are when you want to see the public records. There's this theory that the people are the boss of the government. If you look at any agency's organization chart, it always has the people of the state of Florida at the top. All this is to try and make that a reality. People have very few ways that they can know what their government is doing, and be the boss with regard to the government. Public records requests and sunshine law and voting are the three ways. This is no more of a scam than the Florida Highway Patrol sitting out on Interstate 10 and seeing if people are speeding. Now, when somebody gets a speeding ticket, are they allowed to say to the Florida Highway Patrol that you're just out there to get fines and it's just a scam? And
Well, the FHP officer doesn't personally profit from the speeding ticket, though, right?
I doubt it, but I don't know where all that money goes or what happens to it.
But let me get back to my custodian issue, because that's what's really hanging me up. Wouldn't your argument impose and make the records custodian any valid county email address?
No, sir. The email address that I used was on the letterhead for the minutes for the Board of County Commissioners. I looked at the statutes on who is the head of the agency for a county, and I cite all the statutes in my brief. There's no doubt that the Board of County Commissioners is the head of the agency for Union County, and there's no doubt that the Chapter 119 says that a custodian under that statute is the head of the agency. So that's why I sent that email address where I is. And the record's clear that they got it. The board secretary got it, and they sent it to.
Well, let me ask you a question about, you did get the records, right?
After I filed
After you
suit.
filed the suit, but you continued to litigate after you got the records, right?
Because there were arguments that they didn't violate the law.
So this really isn't about the records, it's about the attorney's fee, right?
It's not just about the attorney's fees, Your Honor. Yes, that's the only remedy left for me to get, but it's about compliance with the law. It's about, you need to understand what the law requires. If this case is affirmed and if it's not reversed, then a couple of things are going to come from it. You have to give your name, potentially, if you want to enforce the
No,
law.
I don't see that at all. I don't see that at all. I see a situation in which you could have a narrow exception in the case of an email, where there's some case law that says that a citizen requesting records doesn't have to make a follow-up request, doesn't have to say, hey, did you get my request? But I can certainly see the need for an exception, at least as a defense to attorney's fees, not with respect to the records, which would essentially say that there is some duty to follow up if you've given somebody no more than an email address. Otherwise, if we rule in your favor, isn't the state of the law going to be that a governmental entity is obligated, on pain of paying attorney's fees, is obligated to send public records to an email address, whether it looks like it belongs to a real person or not? Obligated to send those records.
They are obligated to send public records if public records are requested, and if it's by an email address, then yes. I would suggest to you that if they follow the law, all of the concerns you have will not be concerns if they follow the law.
So if somebody in Nigeria wanted to just create an attorney's fee machine out of this statute and just randomly computer generate thousands of letters directed at county commissions, we'd have county commission employees scurrying around to provide these records to computer-generated email addresses. And that's how this law is supposed to work, in your view.
The law is clear, and I understand your concern. Maybe that's something for the legislature to take up. And there have been attorney general.
We do some things here.
No, I understand.
We don't just read statutes. We do some, I mean, I know some people like to think that all we do is read statutes, but we do have some judgment to exercise here. And I'm asking you if you think this is a good judgment for us to exercise, to say that a governmental entity has an obligation to provide records to an email address.
Absolutely, I'm saying
Okay.
that they have an obligation. I mean, they could have, if they had acknowledged the request and sent an email back, I would have sent an email back saying whatever I needed to say, saying, yes, I'm real. I want these records. I want them to be anonymous. I have business purposes for wanting to be
Well, it
anonymous.
turns out you are real. It turns out you own Consumer Rights LLC, right?
Yes, sir.
And it turns out that you really were entitled to the records. The case is not about that. The case is about whether a governmental entity can be on the hook for attorney's fees for failing to respond to your email. That's really what the case is about, isn't it?
It's about an unlawful refusal, and it's about educating them and the trial courts and everybody else what the law requires, and it requires a response, a timely response, and an acknowledgement in the first place.
All right, you have a little time left. We'll add another minute to your time to give you a decent chance to make rebuttal.
Okay,
And
thank
we'll
you.
add a minute to your time, too, to make it even, all right?
Thank you, Your Honor.
May it please the court, I'm Hope Keating on behalf of the appellee Union County. This matter comes to the court on a final judgment issued after an evidentiary hearing was held pursuant to Section 119.11 Florida statutes, during which time testimony was taken and evidence was presented. And after weighing the pertinent testimony and evidence, the trial court made factual findings that go to two issues that are key in this appeal. First, the trial court found that the records requested did not exist at the time of the request or at the time that the lawsuit was filed, and such evidence is supported by competent substantial, such finding is supported by competent substantial evidence. And second, even if the court were somehow to find that the record requested did exist at the time of the request, there was no unlawful refusal, and any delay in the retrieval of the information and its production was certainly reasonable and justified under the facts of this case.
Well, on your first point, I think Mr. Case agrees that there was no list of emails, no one piece of paper where all these emails existed.
Correct.
But I think the distinction he's making that I didn't see in the trial court's ruling, that the actual, that somewhere electronically perhaps these email addresses did exist at the time of the, how do you respond to that?
Well, first of all, the clerk did testify that there was no list of the addresses, and the information had not been compiled, and it was not being maintained by the county as a record. They were not being maintained in any format that could be downloaded or generated as a record.
Well, apparently it was, because after the lawsuit was filed, it was downloaded and generated.
Well, she also testified there was no integrated computer system, there was no single database server or information technology system that could generate that information into a perceivable format.
But wouldn't it be your duty, though, to notify the requester that the information needs to be compiled and to estimate the cost of doing that? I mean, the information was retrievable, was it not? I mean,
Well, she did. The information was generated after the clerk became aware of the request. She did compile the information into a list. First of all, she testified that there was no way that she could produce that information without creating a document, either creating a list or creating a series of documents, like 54 individual documents, by typing in the name of the email address either in the body of the email or in the header of the email. And
But I guess the problem I have with that argument is if he made a request for, I want all of the emails sent by employee Jim Smith on this day, you would go print that out. I want all of the emails if he knew all 54 of the employees, he would ask for 54 separate things, and that's essentially what's happened here. I guess I'm struggling with your argument that these records didn't exist.
Well, they didn't exist in record form. I mean, because that email address was someplace in the server, it didn't.
But it was on an
wasn't-
email. I mean, that he had to, some of these employees presumably have sent an email at some point in their careers, and so that their email address exists in a document that has to be downloaded from the computer, doesn't it?
Well, what he asked for was a list. He didn't ask for a series of emails.
Or the information that, when compiled, would create a list. I mean, it sounds like he was, I don't want to give him credit for he doesn't deserve it, but he did ask for a list or the things that I could put together and make a list, didn't he?
Right. And the trial court also found, as a matter of law, that email addresses in and of themselves aren't public records. It looked at the definition of public records as the Florida Supreme Court defined them in the Chevin case, and the court said there that that public records don't include all information or everything generated or received by a public agency. It's only that material that has been prepared with the intent of perpetuating, communicating, or formalizing knowledge.
I wish somebody'd tell the Florida Bar that our email addresses are not public records.
I think email addresses, if they are contained on a document that is otherwise a public record, of course, it would be included in that public record. But email addresses, in and of themselves, don't perpetuate, communicate, or formalize any knowledge. They enable records to be communicated, sent, or received, but they themselves don't do that. And I think that the court also, the trial court, cited to the City of Clearwater case that's a case that talked about headers in emails that contain email addresses, and stated that there's no evidence that that information was maintained or generated in the normal course of business.
Wouldn't the procedure in that event to have been to deny the records on the ground that they are exempt?
The court, the clerk, I think the Chapter 119 contemplates that a custodian can compile information that's not otherwise developed or maintained by the agency as a record, and that's what the clerk did here. I think that's Section 119.012F. It contemplates that even though that information does exist, it can be compiled. The custodian can make the election to compile that information, and that's what she did here.
How do you deal with the Bradford County case that was filed as supplemental authority? It seems like it was the same exact request that went to a different small county.
Right. That case, though, came to this court in a different procedural posture. That order that was issued on that case was issued on a motion to dismiss. There was no evidentiary hearing. Here, in this case, we have had a full evidentiary hearing pursuant to Section 119.11, and there are findings of fact on the issues that go to the issues of whether the records existed, and also the circumstances of the email itself that show that any delay in the production of the records was justifiable or reasonable.
Is
Yeah.
that the test? I mean, I think Mr. Case argues that unreasonably withholding is no longer the test. It's if you are a public agency and you don't provide it, that's unlawful.
Well, I believe in the Bradford County case, the verbiage that the court used when it remanded it back to the trial court was for the trial court to determine whether or not the delay was unreasonable under the facts of that case. And also, that was the verbiage, I believe, that the court used in the Liltner case. And also, a case cited in the Liltner case, I believe it was a Jarvis case. So, yeah, looking at it, it does depend on the facts of the case as to whether or not the delay was justified. The other point I'd like to make is that even if the court finds that the records did exist here, the delay, the facts that the trial court, his factual findings show that any justification was reasonable under the facts. The record shows specifically on pages 8 and 9.
Well, is there any evidence that the county was still thinking about doing this, or I thought that the reason that they didn't do it is because they thought it was phishing, to use the term, PH phishing.
That's correct.
Which is a computer term that I suppose refers to
That's correct.
inauthentic emails, right?
Right.
Okay, but let me ask you about that. What's wrong with that? I mean, we don't get into the question of why somebody wants records. That's really off limits. So I guess what I'm saying is even if it was phishing, what's wrong with that?
Well, I know that there's case law that says that the reason that a record is requested is not relevant. But here, I think all the facts go to why there was a justification for any delay or for a refusal. And there are two reasons for that. One is where the email was sent to start with, and also how the email appeared. On pages 8 and 9 of the transcript, this is Mr. Case's testimony. This is what he testified. He said he decided to do some research to determine who was the custodian and who he should send his public records request to. And he determined that the clerk of the court of Union County was the proper custodian. And, however, he then goes on to testify, he said, I decided to send the public records request to the Board of County Commissioners. He knew that the clerk was a custodian, and yet he sent it somewhere else.
Well, why does that matter? I guess, I mean, I agree with you. It seems pretty obvious what's going on here, but if he had sent a written public records request from Attorney Case to the chairman of the Board of County Commissioners, I don't think you'd be making the argument that it was sent to the wrong person and thus we properly didn't respond to it. The chairman would just hand it off to the clerk and it'd get responded. So why does it matter that it went to that other email address?
Well, I think, as the trial court found, it was purposefully designed to appear to deceive. It was sent someplace, I guess, with the hopes that that would be ignored. And Florida law does place some responsibility on the requester to make the request to the right person. It doesn't necessarily have to go to the statutorily designated custodian, but it does have to go to a person who has actual control over a document.
Right, so in my hypothetical, the request goes to the chairman of the Board of County Commissioners, the county manager, whoever's in charge of the county. Would you be making the same argument? Could you make the same argument?
Well, I think in this case, yes, because that's only one part of it. Where it went was only one part of this problem. The other thing was the email itself. And it was addressed, as I said, to an email address found on board county commissioner letterhead, not the clerk's letterhead. It was a generic email address. It was from a generic email address, askforrecords@gmail.com. There was no name of a sender anywhere in the email, in the body or the header or the recipient. It was a long paragraph. There were no indentations.
Why does that matter in light of the fact that there's been an evidentiary hearing and I guess the trial court has found that this request came from Consumer Rights LLC?
Well, it didn't look like it came from anybody or any organization.
What does that go to? I mean, that's where I'm struggling.
It goes to the issue of phishing, and the testimony shown.
But what legally does that go to? What's the legal point?
It goes to the issue of whether or not there was a reasonable justification for the delay in the production of the records.
And where in the statute is the reasonableness? What does that go to? I'm looking at one. I mean, I think this is all about attorney fees at this point. He's got the records about attorney fees.
And the statute now reads unlawful refusal.
Right.
And that includes whether or not an unjustified delay is an unlawful refusal.
So that's the argument. That's really the legal point we need to decide, whether unlawful refusal incorporates a reasonableness requirement.
Right, and I think this court, as in the Bradford County case and in other cases, the Jarvis case, Liltner case, the court looks at the facts of the case to determine whether under the facts the delay was reasonable or justified. I think the court, though, doesn't have to get to that point because it could find on the facts of this case that the record did not exist in the first place. But if it finds that the records did exist, then I believe that the facts here show that any justification was reasonable. Also, one other point with regards to the email is it said, Union County, it wasn't addressed to anybody, Union County, send me all of your employee email addresses. And I think that supports the belief by the person who saw it that it was a phishing attempt and it was not a legitimate public records request. Also, one other thing is that
How do you deal with the Lee versus Board of Trustees Jacksonville Police and Fire Fund case that we decided in 2013 that seems to stand for the proposition that unreasonable is not part of unlawful?
Well, I know that case is under review, the Florida Supreme Court, and it seems to me that case took out a willfulness requirement on the part of the custodian. But in the other cases, for example, going back to the Bradford County case and also the Liltner case, it seems that the court does still consider the facts of the case and whether or not there was a reasonable or justified reason for a delay. There's just one other point I'd like to make is that there are cases cited in the brief by Consumer Rights that for the proposition that a mistake is not a legitimate excuse for noncompliance with a public records request. But the cases cited, there was a clear request to the proper custodian for a record that existed, and it was the custodian's intentional wrongdoing or ineptitude or failure to mitigate a non-mistake that caused the delay of the production of those records. And here, there was no finding by the trial court of any intentional wrongdoing or ineptitude or failure to mitigate a mistake by the recipient. Rather, the trial court found that all the causes for the delay were on the requester's side, and the trial court here found that the email was designed by the requester to be intentionally deceptive, suspicious, and to invite compliance for the purpose of manufacturing attorney's fees.
Yeah, please, court. First thing I want to go over is the custodian. I cited in the brief the section 119.011 paren 5 that defines custodian as follows. The elected or appointed county officer charged with responsibility of maintaining the office having public records or his or her designee. So the board is clearly the head of the agency. And they've actually said that the clerk, who they say was the proper custodian, didn't actually possess some of the records that were requested. So sending the public records request to the head of the agency gets rid of all that questioning on whether or not she actually is the custodian or whether or not she possesses all the records. If you're a person want records of an agency, you can send them to the head of the agency, and that's a proper.
You sent it to an email address, so not the head of the agency. I think Judge Weatherall had mentioned earlier, had the chair of the county commission gotten a letter, then that's a different issue. But here it was just to a unknown email address, an email address that was on a website, but nothing indicating on that, or on minutes, nothing indicating that it was for receipt of records request, right?
As I saw it, and we contend, it was the published email address on the minutes for contacting the Board of County Commissioners. And the statute says that the board is the head of the agency, and it's all of the board members that are the head of the agency. I appreciate that you would send one to the chair, but the statute specifically says that all of the board is the agency.
Let me ask you a question about this. What if the email that you sent to Union County had ended up in the spam folder with their spam filter? Would your position be the same?
Probably, but I'd also want to know why.
Were you hoping it would end up there?
No, sir. I wanted the email addresses for the business purposes that I have for consumer rights. I've taken a lot of criticism for.
Well, let me ask you about that. You said this is not a scam, and I take you at your word. I do. I have no reason to doubt you. But if we were to reverse this case along the lines that you would like for us to do, wouldn't that precedent just be used as a tool for people who would perpetrate scams? Lawyers would be out there then looking for every way to hide the ball on a Public Records Act request with the idea that they'd get attorney's fees later.
What it will do is it will educate the agencies on the rules that they're required to follow in giving people their public records. All they had to do was respond to the public records request. If they had sent me an email saying, "Are you a fisherman, or are you a scammer, or what are you?" I'd have said, I'm a person. I want the records. I want to be anonymous. Just send me the records, please. Thank you. It's not going to infect your computer, nothing along those lines. All they have to do is comply with the rules of the law that are out there in the case law and the Attorney General's opinions and so on and so forth. All consumer rights did, all I did in this case, I've studied the public records law. I used to be a public records lawyer for the state, for the Department of Transportation. I know it inside and out. I know what the rules are. All I did was follow exactly what the rules are. And the people need to know exactly what the rules are so they can know what they need, what they can require of their government in terms of getting public records. Like, how much can they charge? Is this an excessive service charge? And if they see it,
None of that's at issue in this case.
no, sir, it's just a matter of the rules that are out there, whether or not they must be followed, or can an agency come in later and say, well, your purpose was wrong, or this is going to have somebody in Nigeria could send, and I understand that concern, but we can't throw the baby out with the bathwater. It's in the Constitution that people get access to their records. We can't throw that baby out with the bathwater. And if there is some requirement or some rule, then let us know what the rule is up front if we're requesting records, and if we're trying to determine whether or not we can hold the agency responsible for having violated the law, and educate them on what they need to do going forward to do better, which the case law is really clear that is one purpose of an enforcement action, not just to make the lawyers rich by way of attorney's fees. Forget me, it's not about that. It's about educating them on what the rules are with regard to complying with the public records law. That's what's at stake here.
All right.
Thank you, Your Honor.
No, sir, thank you.
Thank you, counsel. Thank you, counsel on both sides. We're going to take a break for 15 minutes, and we invite you to join us for coffee. I guess it's right out this door, is it not? Okay. All right.